Law of Crimes-1. General Principles of Crime. Concept of crime. Law is determined by the political process. Disobedience of law is punished and loosely termed as crime. But disobedience of all law is not crime. For an act done in breach of law of contract, personal law, or civil law may not be termed as crime unless such breach is by some law declared as criminal. Crime is said to be an act which is both forbidden by law against the moral sentiments of the society. Elements of crime. Human being. Crime can be committed by human being only. Mens rea, guilty mind. It means act itself does not make a man guilty unless his intentions were so. Actus reus, physical result. The criminal intent in order to be punishable must become manifest in some voluntary act or omission. Stages of crime. Stages of crime are: intention, preparation, attempt, commission. Ordinarily, first two stages, intention and preparation, do not give rise to any form of criminal liability until specifically defined in law. Liability in criminal law arises when one goes beyond the stage of preparation and attempts to do the prohibited act. Intention. Intention is aim in mind of person. Preparation. Preparation consists in arranging the means or measures for commission of the offense. Attempt. Attempt is direct movement towards the commission after preparation is made. Commission. Commission of crime is execution of an criminal act. Concept of strict liability. Strict liability means liability which does not depend on actual negligence or intent to harm. The doctrine of strict liability has formed its foundation in the England's case Rylands v. Fletcher. Case law, Rylands v. Fletcher. Facts: the defendant owned a mill, where he constructed a reservoir to supply water to the mill. This reservoir was constructed over old coal mines, and the mill owner had no reason to suspect that these old diggings led to an operating colliery. The water in the reservoir ran down the old shafts and flooded the colliery. Held, Blackburn J. held the mill owner to be liable, on the principle that the person who for his own purposes brings on his land and collects and keeps there anything likely to do mischief if it escapes, must keep it in at his peril, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape. On appeal, this principle of liability without fault was affirmed by the House of Lords but restricted to non-natural users vitae. Constructive liability. The phrase constructive liability means and connotes the sense that a person is liable in law for the consequences of an act of another even though he has not done it himself. Relevant sections are: Section 34, Acts done by several persons in furtherance of common intention. Section 149, every member of unlawful assembly, guilty of offense committed in prosecution of common object. Common intention. Section 34, Acts done by several persons in furtherance of common intention. When a criminal act is done by several persons in furtherance of the common intention of all, each of such persons is liable for that act in the same manner as if it were done by him alone. Section 376d, Gang rape. Where a woman is raped by one or more persons constituting a group or acting in furtherance of a common intention, each of those persons shall be deemed to have committed the offense of rape and shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to life, which shall mean imprisonment for the remainder of that person's natural life, and with fine. provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim. Provided further that any fine imposed under this section shall be paid to the victim. Common object. Section 141, Unlawful Assembly. An assembly of 5 or more persons is designated an unlawful assembly if the common object of the persons composing that assembly is: first, to overawe by criminal force, or show of criminal force, the central, or any state government or parliament or the legislature of any state, or any public servant in the exercise of the lawful power of such public servant, or second, to resist the execution of any law of any legal process, or third, to commit any mischief or criminal trespass or other offense, or fourth, by means of criminal force, or show of criminal force, to any person, to take or obtain possession of any property, or to deprive an person of the enjoyment of a right of way, or of the use of water or other incorporeal right of which he is in possession or enjoyment, or to enforce any right or supposed right, or fifth, by means of criminal force, or show of criminal force, or show of criminal force, to compel any person to do what he is not legally bound to do, or to omit to do what he is legally entitled to do. Note: an assembly, which was not unlawful when it assembled, may subsequently become an unlawful assembly. Section 146, Rioting. Whenever force or violence is used by an unlawful assembly, or by any member thereof, in prosecution of the common object of such assembly, every member of such assembly is guilty of the offense of rioting. Section 149, every member of unlawful assembly guilty of offense committed in prosecution of common object. If an offense is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object, every person who, at the time of the committing of that offense, is a member of the same assembly, is guilty of that offense. Inchoate crime/preliminary offenses. Abetment. Section 107, Abatement of a thing. A person abets the doing of thing who: first, instigates any person to do that thing, or secondly, engages with one or more other person or persons in any conspiracy for the doing of that thing, if an act or illegal omission takes place in pursuance of that conspiracy and in order to the doing of that thing, or thirdly, intentionally aids, by an act or illegal omission, the doing of that thing. Other provisions, from Section 108 to Section 120. Section 108, Abettor. Section 108A, Abetment in India of offence outside India. Section 109, Punishment of abetment if the act abetted is committed in consequence and where no express provision is made for its punishment. Section 110, Punishment of abetment if person abetted does act with a different intention from that of abettor. Section 111, Liability of abettor when one act abetted, and different act done. Section 112, Abettor when liable to cumulative punishment for act abetted and for act done. Section 113, Liability of abettor for an effect caused by the act abetted different from that intended by the abettor. Section 114, Abettor present when offense is committed. Section 115, Abetment of offense punishable with death or imprisonment for life. If offense not committed. If act causing harm to be done in consequence. Section 116, Abetment of offense punishable with imprisonment. If offense be not committed. If abettor or person abetted be a public servant whose duty it is to prevent offense. Section 117, abetting commission of offense by the public or by more than 10 persons. Section 118, concealing design to commit offense punishable with death or imprisonment for life. If offense be committed. If offense be not committed. Section 119, public servant concealing design to commit offense which it is his duty to prevent. If offense be committed. If offense be punishable with death, etc. If offense be not committed. Section 120, concealing design to commit offense punishable with imprisonment. If offense be committed. If offense be not committed. Conspiracy. Section 120A, definition of criminal conspiracy. When two or more persons agree to do, or cause to be done, an illegal act, or an act which is not illegal by illegal means, such an agreement is designated a criminal conspiracy. Provided that no agreement except an agreement to commit an offense shall amount to a criminal conspiracy unless some act besides the agreement is done by one or more parties to such agreement in pursuance thereof. Section 120B, punishment of criminal conspiracy. Whoever is a party to a criminal conspiracy to commit an offense punishable with death, imprisonment for life or rigorous imprisonment for term of 2 years or upwards, shall where no express provision is made in this code for the punishment of such conspiracy, be punished in the same manner as if he had abetted such offense. Whoever is a party to a criminal conspiracy other than a criminal conspiracy to commit an offense punishable as aforesaid shall be punished with imprisonment of either description for a term not exceeding 6 months, or with fine or with both. Attempt. Section 121, waging, or attempting to wage war, or abetting waging of war, against the Government of India. Whoever wages war against the Government of India or attempts to wage such war, or abets the waging of such war, shall be punished with death, or imprisonment for life and shall also be liable to fine. General exception. Mistake. Section 76 and 79 of Chapter 4, General Exceptions, of the Indian Penal Code, 1860 explain the provisions about mistake of fact and mistake of law. These provisions are based upon the common law maxim. Ignorantia facti excusat, ignorantia juris non excusat. Ignorance of fact is an excuse, but ignorance of law is not excused. Accident. Section 80, accident in doing a lawful act. Nothing is an offense which is done by accident or misfortune, and without any criminal intention or knowledge in the doing of a lawful act in a lawful manner by lawful means and with proper care and caution. Necessity. Section 81, act likely to cause harm, but done without criminal intent and to prevent other harm. Nothing is an offense merely by reason of its being done with the knowledge that it is likely cause harm, if it be done without any criminal intention to cause harm, and in good faith for the purpose of preventing or avoiding other harm to person or property. Young age. Section 82, act of a child under 7 years of age. Nothing is an offense which is done by a child under 7 years of age. Section 83, act of a child above 7 and under 12 of immature understanding. Nothing is an offense which is done by a child above 7 years of age and under 12, who has not attained sufficient maturity of undertaking to judge of the nature and consequences of his conduct on that occasion. Unsoundness of mind. Section 84, act of a person of unsound mind. Nothing is an offense which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Drunkenness. Section 85, act of a person incapable of judgment by reason of intoxication caused against his will. Nothing is an offense which is done by a person who, at the time of doing it, is by reason of intoxication, incapable of knowing the nature of the act, or that he is doing what is either wrong, or contrary to law. Provided that the thing which intoxicated him was administered to him without his knowledge or against his will. Section 86, offense requiring a particular intent or knowledge committed by one who is intoxicated. In cases where an act done is not an offense, unless done with a particular knowledge or intent, person who does the act in a state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have had if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge or against his will. Right of private defense. Section 96, things done in private defense. Nothing is an offense which is done in the exercise of the right of private defense. Section 97, right of private defense of the body and property. Every person has a right, subject to the restrictions contained in Section 99, to defend. First, his own body, and the body of any other person, against any offense affecting the human body. Secondly, the property, whether movable or immovable, of himself or of any other person, against any act which is an offense falling under the definition of theft, robbery, mischief, or criminal trespass, or which is an attempt to commit theft, robbery, mischief, or criminal trespass. Section 98, right of private defense against the act of a person of unsound mind, etc. When an act, which would otherwise be a certain offense, is not that offense, by reason of the youth, the want of maturity of understanding, the unsoundness of mind, or the intoxication of the person doing that act, or by reason of any misconception on the part of that person, every person has the same right of private defense against that act which he would have if the act were that offense. Section 99, acts against which there is not right of private defense. There is no right of private defense against an act which does not reasonably cause the apprehension of death or of grievous hurt, if done or attempted to be done, by a public servant acting in good faith under color of his office, though that act may not be strictly justifiable by law. Other provisions. Section 100, when the right of private defense of the body extends to causing death. Section 101, when such right extends to causing any harm other than death. Section 102, commencement and continuance of the right of private defense of the body. Section 103, when the right of private defense of property extends to causing death. Section 104, when such right extends to causing any harm other than death. Section 105, commencement and continuance of the right of private defense of property. Section 106, right of private defense against deadly assault when there is risk of harm of innocent person. Specific offenses. Offenses affecting human body. Culpable homicide, murder. Section 299, culpable homicide. Whoever causes death by doing an act with the intention of causing death, or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death, commits the offense of culpable homicide. Section 300, murder. Except in the cases hereinafter excepted, culpable homicide is murder, if the act by which the death is caused is done with the intention of causing death, or 2 ndly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused, or 3 rdly, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death, or 4thly, if the person committing the act knows that it is so imminently dangerous that it must, in all probability, cause death, or such bodily injury as is likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such injury as aforesaid. Section 301, Culpable homicide by causing death of person other than person whose death was intended. If a person, by doing anything which he intends or knows to be likely to cause death, commits culpable homicide, by causing the death of any person, whose death he neither intends, nor knows himself to be likely to cause, the culpable homicide committed, by the offender, is of the description of which, it would have been, if he had caused the death of the person, whose death he intended or knew himself to be likely to cause. Section 302, Punishment for murder. Whoever commits murder shall be punished with death or imprisonment for life and shall also be liable to fine. Section 303, Punishment for murder by life convict. Whoever, being under sentence of imprisonment for life, commits murder, shall be punished with death. Section 304, Punishment for culpable homicide not amounting to murder. Whoever commits culpable homicide not amounting to murder, shall be punished with imprisonment for life, or imprisonment of either description for a term which may extend to 10 years, and shall also be liable to fine. If the act by which the death is caused is done with the intention of causing death, or of causing such bodily injury as is likely to cause death, or with imprisonment of either description for a term which may extend to 10 years, or with fine, or with both. If the act is done with the knowledge that it is likely to cause death, but without any intention to cause death, or to cause such bodily injury as is likely to cause death. Homicide by rash and negligent act. Section 304A, Causing death by negligence. Whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide, shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Hurt and grievous hurt. Section 319, Hurt. Whoever causes bodily pain, disease, or infirmity to any person is said to cause hurt. Section 320, Grievous hurt. The following kinds of hurt only are designated as grievous. First, emasculation. Secondly, permanent privation of the sight of either eye. Thirdly, permanent privation of the hearing of either ear. Fourthly, privation of any member or joint. Fifthly, destruction or permanent impairing of the powers of any member or joint. Sixthly, permanent disfiguration of the head or face. Seventhly, fracture or dislocation of a bone or tooth. Eighthly, any hurt which endangers life, or which causes the sufferer to be during the space of 20 days in severe bodily pain, or unable to follow his ordinary pursuits. Section 321, Voluntarily causing hurt. Whoever does any act with the intention of thereby causing hurt to any person, or with the knowledge that he is likely thereby to cause hurt to any person, and does thereby cause hurt to any person, is said voluntarily to cause hurt. Section 322, Voluntarily causing grievous hurt. Whoever voluntarily causes hurt, if the hurt which he intends to cause or knows himself to be likely to cause is grievous hurt, and if the hurt which he causes is grievous hurt, is said voluntarily to cause grievous hurt. Explanation: a person is not said voluntarily to cause grievous hurt except when he both causes grievous hurt and intends or knows himself to be likely to cause grievous hurt. But he is said voluntarily to cause grievous hurt, if intending or knowing himself to be likely to cause grievous hurt of one kind, he actually causes grievous hurt of another kind. Illustration. A. Intending of knowing himself to be likely permanently to disfigure Z's face, gives Z a blow which does not permanently disfigure Z's face, but which causes Z to suffer severe bodily pain for the space of 20 days. A has voluntarily caused grievous hurt. Section 323, Punishment for voluntarily causing hurt. Whoever, except in the case provided for by Section 334, voluntarily causes hurt, shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine which may extend to 1,000 rupees, or with both. Section 324, Voluntarily causing hurt by dangerous weapons or means. Whoever, except in the case provided for by Section 334, voluntarily causes hurt by means of any instrument for shooting, stabbing or cutting, or any instrument which, used as a weapon of offense, is likely to cause death, or by means of fire or any heated substance, or by means of any poison or any corrosive substance, or by means of any explosive substance or by means of any substance which it is deleterious to the human body to inhale, to swallow, or to receive into the blood, or by means of any animal, shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. Section 325, Punishment for voluntarily causing grievous hurt. Whoever, except in the case provided for by Section 335, voluntarily causes grievous hurt, shall be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine. Section 326, Voluntarily causing grievous hurt by dangerous weapons or means. Whoever, except in the case provided for by Section 335, voluntarily causes grievous hurt by means of any instrument for shooting, stabbing or cutting, or any instrument which, used as a weapon of offense, is likely to cause death, or by means of fire or any heated substance, or by means of any poison or any corrosive substance, or by means of any explosive substance, or by means of any substance which it is deleterious to the human body to inhale, to swallow, or to receive into the blood, or by means of any animal, shall be punished with imprisonment for life, or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Section 326A, Voluntarily causing grievous hurt by use of acid, etc. Whoever causes permanent or partial damage or deformity to, or burns or maims or disfigures or disables, any part or parts of the body of a person or causes grievous hurt by throwing acid on or by administering acid to that person, or by using any other means with the intention of causing or with the knowledge that he is likely to cause such injury or hurt, shall be punished with imprisonment of either description for a term which shall not be less than 10 years but which may extend to imprisonment for life, and with fine, provided that such fine shall be just and reasonable to meet the medical expenses of the treatment of the victim. Provided further that any fine imposed under this section shall be paid to the victim. Section 326B, Voluntarily throwing or attempting to throw acid. Whoever throws or attempts to throw acid on any person or attempts to administer acid to any person, or attempts to use any other means, with the intention of causing permanent or partial damage or deformity or burns or maiming or disfigurement or disability or grievous hurt to that person, shall be punished with imprisonment, of either description for a term which shall not be less than 5 years, but which may extend to 7 years, and shall also be liable to fine. Explanation 1. For the purposes of Section 326A and this section, acid includes any substance which has acidic or corrosive character or burning nature, that is capable of causing bodily injury leading to scars or disfigurement or temporary or permanent disability. Explanation 2. For the purposes of Section 326A and this section, permanent or partial damage or deformity shall not be required to be irreversible. Section 327, voluntarily causing hurt to extort property, or to constrain to an illegal to an act. Whoever voluntarily causes hurt, for the purpose of extorting from the sufferer, or from any person interested in the sufferer, any property or valuable security, or of constraining the sufferer or any person interested in such sufferer to do anything which is illegal, or which may facilitate the commission of an offense, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Other provisions on hurt and grievous hurt. Section 328, causing hurt by means of poison, etc., with intent to commit an offense. Section 329, voluntarily causing grievous hurt to extort property, or to constrain to an illegal act. Section 330, voluntarily causing hurt to extort confession, or to compel restoration of property. Section 331, voluntarily causing grievous hurt to extort confession, or to compel restoration of property. Section 332, voluntarily causing hurt to deter public servant from his duty. Section 333, voluntarily causing grievous hurt to deter public servant from his duty. Section 334, voluntarily causing hurt on provocation. Section 335, voluntarily causing grievous hurt on provocation. Section 336, act endangering life or personal safety of others. Section 337, causing hurt by act endangering life or personal safety of others. Section 338, causing grievous hurt by act endangering life or personal safety of others. Kidnapping and abduction. Section 359, kidnapping. Kidnapping is of two kinds, kidnapping from India and kidnapping from lawful guardianship. Section 360, kidnapping from India. Whoever conveys any person beyond the limits of India without the consent of that person, or of some person legally authorized to consent on behalf of that person, is said to kidnap that person from India. Section 361, kidnapping from lawful guardianship. Whoever takes or entices any minor under 16 years of age if a male, or under 18 years of age if a female, or any person of unsound mind, out of the keeping of the lawful guardian of such minor or person of unsound mind, without the consent of such guardian, is said to kidnap such minor or person from lawful guardianship. Explanation: the words lawful guardian in this section include any person lawfully entrusted with the care or custody of such minor or other person. Section 362, abduction. Whoever by force compels, or by any deceitful means induces, any person to go from any place, is said to abduct that person. Section 363, punishment for kidnapping. Whoever kidnaps any person from India or from lawful guardianship, shall be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine. Section 364, kidnapping or abducting in order to murder. Whoever kidnaps or abducts any person in order that such person may be murdered or may be so disposed of as to be put in danger of being murdered, shall be punished with imprisonment for life or rigorous imprisonment for a term which may extend to 10 years, and shall also be liable to fine. Wrongful restraint and wrongful confinement. Section 339, wrongful restraint. Whoever voluntarily obstructs any person so as to prevent that person from proceeding in any direction in which that person has a right to proceed, is said wrongfully to restrain that person. Exception: the obstruction of a private way over land or water which a person in good faith believes himself to have a lawful right to obstruct, is not an offence within the meaning of this section. Illustration. A obstructs a path along which Z has a right to pass, a not believing in good faith that he has a right to stop the path. Z is thereby prevented from passing. A wrongfully restrains Z. Section 340, Wrongful Confinement. Whoever wrongfully restrains any person in such a manner as to prevent that person from proceedings beyond certain circumscribing limits, is said wrongfully to confine that person. Illustrations. Illustration 1, A causes Z to go within a walled space, and locks Z in. Z is thus prevented from proceeding in any direction beyond the circumscribing line of wall. A wrongfully confines Z. Illustration 2, B, A places man with firearms at the outlets of a building and tells Z that they will fire at Z if Z attempts leave the building. A wrongfully confines Z. Section 341, Punishment for wrongful restraint. Whoever wrongfully restrains any person shall be punished with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 500 rupees, or with both. Section 342, Punishment for wrongful confinement. Whoever wrongfully confines any person shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine which may extend to 1,000 rupees, or with both. Section 343, Wrongful confinement for 3 or more days. Whoever wrongfully confines any person for 3 days, or more, shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Section 344, Wrongful confinement for 10 or more days. Whoever wrongfully confines any person for 10 days, or more, shall be punished with imprisonment of either description for a term which may extend to 3 years, and shall also be liable to fine. Section 345, Wrongful confinement of person for whose liberation writ has been issued. Whoever keeps any person in wrongful confinement, knowing that a writ for the liberation of that person has been duly issued, shall be punished with imprisonment of either description for a term which may extend to 2 years in addition to any term of imprisonment to which he may be liable under any other section of this chapter. Section 346, Wrongful confinement in secret. Whoever wrongfully confines any person in such manner as to indicate an intention that the confinement of such person may not be known to any person interested in the person so confined, or to any public servant, or that the place of such confinement may not be known to or discovered by any such person or public servant as hereinbefore mentioned, shall be punished with imprisonment of either description for a term which may extend to 2 years in addition to any other punishment to which he may be liable for such wrongful confinement. Section 347, Wrongful confinement to extort property, or constrain to a legal act. Whoever wrongfully confines any person for the purpose of extorting from the person confined, or from any person interested in the person confined, any property or valuable security, or of constraining the person confined or any person interested in such person to do anything illegal or to give any information which may facilitate the commission of an offence, shall be punished with imprisonment of either description for a term which may extend to 3 years, and shall also be liable to fine. Section 348, Wrongful confinement to extort confession, or compel restoration of property. Whoever wrongfully confines any person for the purpose of extorting from the person confined or any person interested in the person confined any confession or any information which may lead to the detection of an offence or misconduct, or for the purpose of constraining the person confined or any person interested in the person confined to restore or to cause the restoration of any property or valuable security or to satisfy any claim or demand, or to give information which may lead to the restoration of any property or valuable security, shall be punished with imprisonment of either description for a term which may extend to 3 years, and shall also be liable to fine. Assault. Section 351, Assault. Whoever makes any gesture, or any preparation intended. Assault. Section 351, Assault. Whoever makes any gesture, or any preparation intending or knowing it to be likely that such gesture or preparation will cause any person present to apprehend that he who makes that gesture or preparation is about to use criminal force to that person, is said to commit an assault. Explanation: mere words do not amount to an assault. But the words which a person uses may give to his gestures or preparations such a meaning as may make those gestures or preparations amount to an assault. Illustrations. Illustration 1. A shake his fist at Z, intending or knowing it to be likely that he may thereby cause Z to believe that A is about to strike Z. A has committed an assault. Illustration 2. A begins to unloose the muzzle of a ferocious dog, intending or knowing it to be likely that he may thereby cause Z to believe that he is about to cause the dog to attack Z. A has committed an assault upon Z. Illustration 3. A takes up a stick, saying to Z, "I will give you a beating." Here, though the words used by A could in no case amount to an assault, and though the mere gesture, unaccompanied by any other circumstances, might not amount to an assault, the gesture explained by the words may amount to an assault. Section 352, Punishment for assault or criminal force otherwise than on grave provocation. Whoever assaults or uses criminal force to any person otherwise than on grave and sudden provocation given by that person, shall be punished with imprisonment of either description for a term which may extend to 3 months, or with fine which may extend to 500 rupees, or with both. Section 353, Assault or criminal force to deter public servant from discharge of his duty. Whoever assaults or uses criminal force to any person being a public servant in the execution of his duty as such public servant, or with intent to prevent or deter that person from discharging his duty as such public servant, or in consequence of anything done or attempted to be done by such person to the lawful discharge of his duty as such public servant, shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Section 354, Assault or criminal force to woman with intent to outrage her modesty. Whoever assaults or uses criminal force to any woman, intending to outrage or knowing it to be likely that he will thereby outrage her modesty, shall be punished with imprisonment of either description for a term which shall not be less than 1 year but which may extend to 5 years, and shall also be liable to fine. Criminal force. Section 350, Criminal force. Whoever intentionally uses force to any person, without that person's consent, in order to the committing of any offense, or intending by the use of such force to cause, or knowing it to be likely that by the use of such force he will cause injury, fear, or annoyance to the person to whom the force is used, is said to use criminal force to that other. Illustrations. Illustration 1, Z is sitting in a moored boat on a river. A unfastens the moorings, and thus intentionally causes the boat to drift down the stream. Here A intentionally causes motion to Z, and he does this by disposing substances in such a manner that the motion is produced without any other action on any person's part. A has therefore intentionally used force to Z, and if he has done so without Z's consent, in order to the committing of any offense, or intending or knowing it to be likely that this use of force will cause injury, fear, or annoyance to Z, A has used criminal force to Z. Illustration 2, Z is riding in a chariot. A lashes Z's horses, and thereby causes them to quicken their pace. Here A has caused change of motion to Z by inducing the animals to change their motion. A has therefore used force to Z, and if A has done this without Z's consent, intending or knowing it to be likely that he may thereby injure, frighten, or annoy Z, A has used criminal force to Z. Illustration 3, Z is riding in a palanquin. A, intending to rob Z, seizes the pole and stops the palanquin. Here A has caused cessation of motion to Z, and he has done this by his own bodily power. A has therefore used force to Z, and as A has acted thus intentionally, without Z's consent, in order to the commission of an offense, A has used criminal force to Z. Illustration 4, A intentionally pushes against Z in the street. Here A has by his own bodily power moved his own person so as to bring it into contact with Z. He has therefore intentionally used force to Z, and if he has done so without Z's consent, intending or knowing it to be likely that he may thereby injure, frighten, or annoy Z, he has used criminal force to Z. Illustration 5, A throws a stone, intending or knowing it to be likely that the stone will be thus brought into contact with Z, or with Z's clothes, or with something carried by Z, or that it will strike water and dash up the water against Z's clothes or something carried by Z. Here, if the throwing of the stone produce the effect of causing any substance to come into contact with Z, or Z's clothes, A has used force to Z, and if he did so without Z's consent, intending thereby to injure, frighten, or annoy Z, he has used criminal force to Z. Illustration 6, A intentionally pulls up a woman's veil. Here A intentionally uses force to her, and if he does so without her consent intending or knowing it to be likely that he may thereby injure, frighten, or annoy her, he has used criminal force to her. Illustration 7, Z is bathing. A pour into the bath water which he knows to be boiling. Here A intentionally by his own bodily power causes such motion in the boiling water as brings that water into contact with Z, or with other water so situated that such contact must affect Z's sense of feeling. A has therefore intentionally used force to Z, and if he has done this without Z's consent intending or knowing it to be likely that he may thereby cause injury, fear, or annoyance to Z, A has used criminal force. Illustration 8, A incites a dog to spring upon Z, without Z's consent. Here, if A intends to cause injury, fear, or annoyance to Z, he uses criminal force to Z. Offenses against property. Theft. Section 378, Theft. Whoever, intending to take dishonestly any movable property out of the possession of any person without that person's consent, moves that property in order to such taking, is said to commit theft. Explanation 1. A thing so long as it is attached to the earth, not being movable property, is not the subject of theft, but it becomes capable of being the subject of theft as soon as it is severed from the earth. Explanation 2. A moving effected by the same act which affects the severance may be a theft. Explanation 3. A person is said to cause a thing to move by removing an obstacle which prevented it from moving or by separating it from any other thing, as well as by actually moving it. Explanation 4. A person, who by any means causes an animal to move, is said to move that animal, and to move everything which, in consequence of the motion so caused, is moved by that animal. Explanation 5. The consent mentioned in the definition may be express or implied and may be given either by the person in possession, or by any person having for that purpose authority either express or implied. Section 379, Punishment for Theft. Whoever commits theft shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. Other provisions. Section 380, Theft in dwelling house, etc. Section 381, Theft by clerk or servant of property in possession of master. Section 382, Theft after preparation made for causing death, hurt or restraint in order to the committing of the theft. Extortion. Section 383, Extortion. Whoever intentionally puts any person in fear of any injury to that person, or to any other, and thereby dishonestly induces the person so put in fear to deliver to any person any property, or valuable security or anything signed or sealed which may be converted into a valuable security, commits extortion. Illustrations. Illustration 1. A threatens to publish a defamatory libel concerning Z unless Z gives him money. He thus induces Z to give him money. A has committed extortion. Illustration 2. A threatens Z that he will keep Z's child in wrongful confinement, unless Z will sign and deliver to A promissory note binding Z to pay certain monies to A. Z sings and delivers the note. A has committed extortion. Illustration 3. A threatens to send clubmen to plow up Z's field unless Z will sign and deliver to B a bond binding Z under a penalty to deliver certain produce to B, and thereby induces Z to sign and deliver the bond. A has committed extortion. Illustration 4. A, by putting Z in fear of grievous hurt, dishonestly induces Z to sign or affix his seal to a blank paper and deliver it to A. Z sings and delivers the paper to A. Here, as the paper so signed may be converted into a valuable security. A has committed extortion. Robbery and dacoity. Section 390, Robbery. In all robbery there is either theft or extortion. When theft is robbery if, in order to the committing of the theft, or in committing the theft, or in carrying away or attempting to carry away property obtained by the theft, the offender, for that end voluntarily causes or attempts to cause to any person death or hurt or wrongful restraint, or fear of instant death or of instant hurt, or of instant wrongful restraint. When extortion is robbery if the offender, at the time of committing the extortion, is in the presence of the person put in fear, and commits the extortion by putting that person in fear of instant death, of instant hurt, or of instant wrongful restraint to that person or to some other person, and, by so putting in fear, induces the person so put in fear then and there to deliver up the thing extorted. Explanation: the offender is said to be present if he is sufficiently near to put the other person in fear of instant death, of instant hurt, or of instant wrongful restraint. Illustrations. Illustration 1. A holds Z down, and fraudulently takes Z's money and jewels from Z's clothes, without Z's consent. Here A has committed theft, and, in order to the committing of that theft, has voluntarily caused wrongful restraint to Z. A has therefore committed robbery. Illustration 2. A meets Z on the high road, shows a pistol, and demands Z's purse. Z, in consequence, surrenders his purse. Here A has extorted the purse from Z by putting him in fear of instant hurt and being at the time of committing the extortion in his presence. A has therefore committed robbery. Illustration 3. A meets Z and Z's child on the high road. A takes the child, and threatens to file it down a precipice, unless Z delivers his purse. Z, in consequence, delivers his purse. Here A has extorted the purse from Z, by causing Z to be in fear of instant hurt to the child who is there present. A has therefore committed robbery on Z. Illustration 4. A obtains property from Z by saying your child is in the hands of my gang and will be put to death unless you send us 10,000 rupees. This is extortion, and punishable as such, but it is not robbery, unless Z is put in fear of the instant death of his child. Section 391, Dacoity. When 5 or more persons conjointly commit or attempt to commit a robbery, or where the whole number of persons conjointly committing or attempting to commit a robbery, and persons present and aiding such commission or attempt, amount to 5 or more, every person so committing, attempting, or aiding, is said to commit dacoity. Section 392, Punishment for Robbery. Whoever commits robbery shall be punished with rigorous imprisonment for a term which may extend to 10 years, and shall also be liable to fine, and, if the robbery be committed on the highway between sunset and sunrise, the imprisonment may be extended to 14 years. Section 393, Attempt to commit robbery. Whoever attempts to commit robbery shall be punished with rigorous imprisonment for a term which may extend to 7 years and shall also be liable to fine. Section 394, Voluntarily causing hurt in committing robbery. If any person, in committing or in attempting to commit robbery, voluntarily causes hurt, such person, and any other person jointly concerned in committing or attempting to commit such robbery shall be punished with imprisonment for life, or with rigorous imprisonment for a term which may extend to 10 years, and shall also be liable to fine. Section 395, Punishment for dacoity. Whoever commits dacoity shall be punished with imprisonment for life, or with rigorous imprisonment for a term which may extend to 10 years and shall also be liable to fine. Section 396. Dacoity with murder. If any one of 5 or more persons, who are conjointly committing dacoity, commits murder in so committing dacoity, every one of those persons shall be punished with death, or imprisonment for life, or rigorous imprisonment for a term which may extend to 10 years, and shall also be liable to fine. Section 397. Robbery, or dacoity, with attempt to cause death or grievous hurt. If, at the time of committing robbery or dacoity, the offender uses any deadly weapon, or causes grievous hurt to any person, or attempts to cause death or grievous hurt to any person, the imprisonment with which such offender shall be punished shall not be less than 7 years. Section 398, Attempt to commit robbery or dacoity when armed with deadly weapon. If, at the time of attempting to commit robbery or dacoity, the offender is armed with any deadly weapon, the imprisonment with which such offender shall be punished shall not be less than 7 years. Section 399, Making preparation to commit dacoity. Whoever makes any preparation for committing dacoity, shall be punished with rigorous imprisonment for a term which may extend to 10 years, and shall also be liable to fine. Section 400. Punishment for belonging to gang of dacoits. Whoever, at any time after the passing of this act, shall belong to a gang of persons associated for the purpose of habitually committing dacoity, shall be punished with imprisonment for life, or with rigorous imprisonment for a term which may extend to 10 years, and shall also be liable to fine. Section 401, Punishment for belonging to gang of thieves. Whoever, at any time after the passing of this act, shall belong to any wandering or other gang of persons associated for the purpose of habitually committing theft or robbery, and not being a gang of thugs or dacoits, shall be punished with rigorous imprisonment for a term which may extend to 7 years, and shall also be liable to fine. Section 402, Assembling for purpose of committing dacoity. Whoever, at any time after the passing of this act, shall be one of 5 or more persons assembled for the purpose of committing dacoity, shall be punished with rigorous imprisonment for a term which may extend to 7 years, and shall also be liable to fine. Cheating. Section 415, Cheating. Whoever, by deceiving any person, fraudulently or dishonestly induces the person so deceived to deliver any property to any person, or to consent that any person shall retain any property, or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit if he were not so deceived, and which act or omission causes or is likely to cause damage or harm to that person in body, mind, reputation, or property, is said to cheat. Explanation: a dishonest concealment of facts is a deception within the meaning of this section. Section 416, Cheating by personation. A person is said to cheat by personation if he cheats by pretending to be some other person, or by knowingly substituting one person for or another, or representing that he or any other person is a person other than he or such other person really is. Explanation: the offense is committed whether the individual personated is a real or imaginary person. Section 417, Punishment for cheating. Whoever cheats shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine, or with both. Section 418, Cheating with knowledge that wrongful loss may ensue to person whose interest offender is bound to protect. Whoever cheats with the knowledge that he is likely thereby to cause wrongful loss to a person whose interest in the transaction to which the cheating relates, he was bound, either by law, or by a legal contract, to protect, shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. Section 419. Punishment for cheating by personation. Whoever cheats by personation shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. Section 420, Cheating and dishonestly inducing delivery of property. Whoever cheats and thereby dishonestly induces the person deceived to deliver any property to any person, or to make, alter, or destroy the whole or any part of a valuable security, or anything which is signed or sealed, and which is capable of being converted into a valuable security, shall be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine. Offenses against state and public tranquility. Sedition. Section 124A, Sedition. Whoever by words, either spoken or written, or by signs, or by visible representation, or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards, the government established by law in India shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years, to which fine may be added, or with fine. Explanation 1. The expression disaffection includes disloyalty and all feelings of enmity. Explanation 2. Comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means, without exciting or attempting to excite hatred, contempt, or disaffection, do not constitute an offense under this section. Explanation 3. Comments expressing disapprobation of the administrative or other action of the government without exciting or attempting to excite hatred, contempt, or disaffection, do not constitute an offense under this section. Other provisions, Section 125 to 130. Section 125. Waging war against any Asiatic power in alliance with the Government of India. Section 126. Committing depredation on territories of power at peace with the Government of India. Section 127. Receiving property taken by war or depredation mentioned in sections 125 and 126. Section 128. Public servant voluntarily allowing prisoner of state or war to escape. Section 129. Public servant negligently suffering such prisoner to escape. Section 130. Aiding escape of, rescuing or harboring such prisoner. Unlawful assembly. Section 141. Unlawful assembly. An assembly of 5 or more persons is designated an unlawful assembly if the common object of the persons composing that assembly is: first, to overawe by criminal force, or show of criminal force, the central or any state government or parliament or the legislature of any state, or any public servant in the exercise of the lawful power of such public servant, or second, to resist the execution of any law of any legal process, or third, to commit any mischief or criminal trespass or other offense, or fourth, by means of criminal force, or show of criminal force, to any person, to take or obtain possession of any property, or to deprive an person of the enjoyment of a right-of-way, or of the use of water or other incorporeal right of which he is in possession or enjoyment, or to enforce any right or supposed right, or 5th, by means of criminal force, or show of criminal force, to compel any person to do what he is not legally bound to do, or to omit to do what he is legally entitled to do. Note: an assembly, which was not unlawful when it assembled, may subsequently become an unlawful assembly. Section 142, being member of unlawful assembly. Whoever, being aware of facts which render any assembly an unlawful assembly, intentionally joins that assembly, or continues in it, is said to be a member of unlawful assembly. Section 143, Punishment. Whoever is a member of an unlawful assembly, shall be punished with imprisonment of either description for a term which may extend to 6 months or with fine or with both. Section 144, Joining unlawful assembly armed with deadly weapon. Whoever being armed with any deadly weapon, or with anything which, used as a weapon of offense is likely to cause death, is member of an unlawful assembly, shall be punished with imprisonment of either description of a term which may extend to 2 years, or with fine, or with both. Section 145, Joining or continuing in unlawful assembly, knowing it has been commanded to disperse. Whoever joins or continues in an unlawful assembly, knowing that such unlawful assembly has been commanded in the manner prescribed by law to disperse, shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Rioting. Section 146, Rioting. Whenever force or violence is used by an unlawful assembly, or by any member thereof, in prosecution of the common object of such assembly, every member of such assembly is guilty of the offense of rioting. Section 147, Punishment for rioting. Whoever is guilty of rioting, shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Other provisions, Section 148 to 158. Section 148, Rioting, armed with deadly weapon. Section 149, Every member of unlawful assembly guilty of offense committed in prosecution of common object. Section 150, Hiring, or conniving at hiring, of persons to join unlawful assembly. Section 151, Knowingly joining or continuing in assembly of 5 or more persons after it has been commanded to disperse. Section 152, Assaulting or obstructing public servant when suppressing riot, etc. Section 153, Wantonly giving provocation, with intent to cause riot. If rioting be committed. If not committed. Section 153A, Promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to maintenance of harmony. Offense committed in place of worship, etc. Section 153A, Punishment for knowingly carrying arms in any procession or organizing or holding or taking part in any mass drill or mass training with arms. Section 153B, Imputation, Assertions prejudicial to national integration. Section 154, Owner or occupier of land on which an unlawful assembly is held. Section 155, Liability of person for whose benefit riot is committed. Section 156, Liability of agent of owner or occupier for whose benefit riot is committed. Section 157, Harboring persons hired for an unlawful assembly. Section 158, Being hired to take part in an unlawful assembly or riot, or to go armed. Affray. Section 159, Affray. When two or more persons, by fighting in a public place, disturb the public peace, they are said to commit an affray. Section 160, Punishment for committing affray. Whoever commits an affray, shall be punished with imprisonment of either description for a term which may extend to 1 month, or with fine which may extend to 100 rupees, or with both. Offences against marriage. Bigamy. Section 494, Marrying again during lifetime of husband or wife. Whoever, having a husband or wife living, marries in any case in which such marriage is void by reason of its taking place during the life of such husband or wife, shall be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine. Exception: this section does not extend to any person whose marriage with such husband or wife has been declared void by a court of competent jurisdiction, nor to any person who contracts a marriage during the life of a former husband or wife, if such husband or wife, at the time of the subsequent marriage, shall have been continually absent from such person for the space of 7 years, and shall not have been heard of by such person as being alive within that time, provided the person contracting such subsequent marriage shall, before such marriage takes place, inform the person with whom such marriage is contracted of the real state of facts so far as the same are within his or her knowledge. Section 495, Same offense with concealment of former marriage from person with whom subsequent marriage is contracted. Whoever commits the offense defined in the last preceding section, having concealed from the person with whom the subsequent marriage is contracted, the fact of the former marriage, shall be punished with imprisonment of either description for a term which may extend to 10 years, and shall also be liable to fine. Section 496, Marriage ceremony fraudulently gone through without lawful marriage. Whoever, dishonestly or with a fraudulent intention, goes through the ceremony of being married, knowing that he is not thereby lawfully married, shall be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine. Adultery. Section 497, Adultery. Whoever has sexual intercourse with a person who is and whom he knows or has reason to believe to be the wife of another man, without the consent or connivance of that man, such sexual intercourse not amounting to the offense of rape, is guilty of the offense of adultery, and shall be punished with imprisonment of either description for a term which may extend to 5 years, or with fine, or with both. In such case the wife shall not be punishable as an abettor. Section 498, Enticing or taking away or detaining with criminal intent a married woman. Whoever takes or entices away any woman who is and whom he knows or has reason to believe to be the wife of any other man, from that man, or from any person having the care of her on behalf of that man, with intent that she may have illicit intercourse with any person, or conceals or detains with that intent any such woman, shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both.